It's been an eventful few days for South Africa's police service as senior leaders battled it out in court. The Gauteng High Court in Pretoria on Wednesday heard Deputy National Police Commissioner for Crime Detection, Shadrack Sibiya's urgent application to review and set aside the instruction by National Police Commissioner Fannie Masemola that his deputy stay at home. But what are the critical legal questions before the Superior Court? Hello and welcome, I'm Zoleka Qodashe, and we'll be unpacking Sibiya's urgent application to return to work. Deputy National Police Commissioner for Crime Detection, Lieutenant General Shadrack Sibiya, says the dominoes began falling on the 6th of July this year. It was on this date when KwaZulu-Natal Police Commissioner Nhlanhla Mkhwanazi made damning allegations against him.
On the 26th of March 2025, this year, a total of 121 case dockets that were under investigation were taken away from the task team as directed by a Deputy National Commissioner Crime Detection, a Lieutenant General Sibiya, who was acting on the instruction of the Minister of Police to disband the team. This was done without the authority of the National Commissioner, nor I, as a Provincial Commissioner, was never informed. These case dockets have since March been sitting at the head office ever since, without any investigation work done on them. 5 of these dockets had already instruction to arrest perpetrators, but nothing has been done because a Lieutenant General Sibiya, being instructed by the Minister, executing instruction of the Minister, withdrew all these dockets and they are sitting in archive in his office in Pretoria. God knows why.
Just 9 days later, on the 15th of July, the consequences of the explosive allegations supposedly became clear.
I asked him to stay home while at the same time I'm doing internal investigation. The internal investigation will determine as to what next course of action will be taken. I can't preempt. Probably the investigation can say, no, there's nothing, come back, and then we will continue working. Or if there's some other things, there will be other processes that will follow.
But did Masemola have the powers to take such action? Sibiya's legal counsel argues the negative. Sibiya argues that he's been ordered to stay at home on the strength of untested allegations which were made by a single individual during a press briefing, hardly the appropriate forum for such allegations. The second-in-command also submits that his superior acted beyond the scope of his powers and statutory authority, and therefore the decision must be reviewed and set aside. Thus, Sibiya seeks to demonstrate to the Superior Court that Masemola's move constitutes administrative action. Administrative action refers to action taken or the failure to take action by an organ of state. This action has an impact on the rights of a party. This exercise of public power must be grounded on existing legislation, which means there must be a statute that gives the organ of state the authority to make such a decision. This administrative action must be lawful, procedurally fair, and should not be arbitrary. Failure to meet these requirements could subject the decision to judicial review and runs the risk of being set aside. The statute which governs administrative action is the Promotion of Administrative Justice Act. Section 6 of the Act prescribes that a court has the power to judicially review an administrative action if a mandatory and material procedure or condition prescribed by an empowering provision was not complied with. The action was procedurally unfair, among others.
As a departure point, a thing is unlawful if it is not authorized by the law. And then he goes on to say, with all due respect, before considering the lawfulness of the suspension, this court must address the issue of the source of the power to suspend. The correct starting point is what is the source of the authority for any suspension decision to be taken. And if we can demonstrate that there is no source of authority to take any disciplinary action in the manner in which it has been taken against Lieutenant General Sibiya, that there may be some merit to the allegations or no merit to the allegations doesn't in actual fact arise, because what Justice Mkhwanazi correctly says, with all due respect, Justice Mkhwanazi, is that you need to start with the source of the power. Because if the source of the power doesn't permit the administrative action in question, then everything that follows is tainted by unlawfulness.
Sibiya relies on the disciplinary regulations, which regulates the discipline of all SAPS members. He posits that these do not empower the top cop to effect a decision such as a stay-at-home order. Regulation 6.1 stipulates that the National Police Commissioner or a Provincial Police Commissioner may appoint a disciplinary officer who may initiate investigations into the conduct of an SAPS member, as per Regulation 6.2. Therefore, Masemola's confirmation that he made the decision after the top cop cited his alarm at the allegations against his deputy is unlawful, as explained by Sibiya's counsel.
Before we can even get into a labor type of analysis of is this a fair practice, has the charge been adequately demonstrated, is the charge sheet specifically detailed, and all those kinds of wonderful things, we have to go back to the source of the power. And if I can demonstrate that there's no source of the power, then with all due respect, it doesn't matter whether there is some currency to General Masemola's allegations or there aren't, because if I can demonstrate that the way in which he sought to discipline fell outside the disciplinary regulations, then as a matter of the rule of law, that's gone.
But one of the critical questions before the court is whether the order that Sibiya stays at home constitutes suspension.
Ultimately, the matter is going to come down to whether that instruction was a suspension. I think Mr. Sibiya is really saying that, as far as he understood it, he's suspended. And if you are suspended, then there's a specific process in terms of Regulation 8 that has to be followed. And that includes him being afforded an opportunity to make representations. So this instruction to stay at home did not have an opportunity to make representations, and he took it as if it's a suspension. But what the Commissioner has said, well, if it was a suspension, then he wouldn't have the ability to have his work devices. It would have followed a completely different practical course, and all he's being asked to hear is not attend the office.
Regulation 8 highlights the procedural steps to follow in cases of serious misconduct against SAPS members. It prescribes, among others, that an employer representative must, within 15 working days, charge the employee with misconduct by serving a written notice to attend the disciplinary hearing in the form determined by the National Commissioner. Suspension, leave of absence, or stay-at-home order. Is it just semantics? No. There are legal consequences which differ for each.
What is interesting about this thing is the manner in which the so-called suspension has been framed. It has been framed not as a suspension from employment pending the outcome of a disciplinary inquiry. It is in fact a leave of absence. It's an enforced leave of absence rather than a suspension. Now, it may sound semantic to frame it in that way or to make that distinction, but I think it is an important one. There's no such thing in the disciplinary code for an enforced leave of absence. And a leave of absence is normally something that happens by request. It's voluntary for some family issue and so on, where you say, listen, I need to take some time out, instead of being forced under these circumstances to take it. And I think that's the sort of the territory that we're in.
So if Masemola did not in fact suspend his deputy, is it necessary to invoke the disciplinary regulations?
The National Commission says in the answering affidavit, I did not exercise powers emanating from the regulator, i.e. I did not put the applicant on a precautionary.
Yes.
And in order to establish whether that is possibly correct, if you look at SS2,
Yes.
nowhere is there reference to precautionary suspension. Nowhere is there reference
Yes.
to the clause that
Yes.
deals with precautionary.
That's exactly the point.
What is apparent from these notices is that 3, given the seriousness of the said allegation, you are hereby instructed
Yes.
to stay at home.
Yes.
Pending the outcome.
Yes.
Regulation 10 also stipulates that Sibiya must be afforded a reasonable opportunity to make written submissions, and action can only be taken against him after they have been considered. Sibiya argues that he was never afforded this opportunity and accuses his boss of bias with unjustified favor towards Mkhwanazi. He says this brings into doubt whether the head of the police service can be an independent and neutral arbiter in disciplinary proceedings against him. Despite this, Sibiya maintains his innocence and disputes assertions that he withdrew the investigation dockets from the Political Killings Task Team or caused investigation delays. He submits that the role he played was within the scope and course of instructions from Masemola.
Where I'm standing, I'm quite sure and quite confident that I've done nothing wrong, and it is for the judge at the ultimate end to finally say whether I'm guilty or not. But I can safely tell you that I'm actually waiting for a positive outcome. I do know that I am not involved in any wrongdoing, and we will be cleared.
Okay, but did you interfere or not interfere in the disbanding of the PKTT?
I never interfered, and what I also can say is that in the whole system, it can't be that I'm the only one who interfered, who did this and that. Over and above, there are many people that are in the system with a matter that has been handled since January, with a lot of feedback being given, a lot of meetings being held, going in and out of Parliament discussing the same matter. Now, how do you then pin it on one individual and say this person did 1, 2, 3, 4?
Stay with us, because when we come back, we will recount Masemola's assertion of how the squabble within the police top brass in fact began when then Police Minister Senzo Mchunu issued the directive to disband the Political Killings Task Team. Thanks for staying with us as we unpack further the legal battle among the country's top cops, where even the genesis of this conflict is in dispute. Sibiya alleges that he was issued with a stay-at-home order because of the July 6th briefing. But nay, says Masemola. He alleges that it's because of a series of events that transpired months before. Let's unpack what the head of the cops submitted before the High Court. Masemola places us firmly on the 31st of December 2024. He alleges that his annual leave was to begin on this day and had been approved by his political head, then Police Minister Senzo Mchunu. Despite this, Mchunu issued the directive for the disbandment of the Political Killings Task Team on the very same day. The top cop alleges that the ministerial directive came to his attention on the 2nd of January, and he was able to study it further when he returned from leave on the 14th of that same month. The minister allegedly directed that the unit be disbanded immediately and required a preliminary report on the 20th of January 2025 and a final report later that month. Masemola says that while he accepted that the directive fell within the oversight powers of the minister, he could not be dictated to about how and when he would give effect to that order. It was then that he engaged with his deputy and instructed him to draft a phased-out plan for the end of the task team. However, Masemola alleges that Sibiya defied this instruction and continued to give instructions to the PKTT to hand over their dockets within 7 days from the 4th of February 2025. This despite Masemola also working on an amended phased-out plan with Crime Intelligence Head Lieutenant General Dumisani Khumalo, who was also arrested earlier this year for alleged unlawful senior appointments. This, Masemola says, is what triggered the leave of absence 5 months later.
Powers that the National Commissioner have to manage and control the police service is not codification. We don't have a codified legal system where everything is regulated by a law or a regulation. It is impossible in the police structure to do that. And I wanted to use a very simple example. If there is a shooting incident where a police officer is involved and the commander comes there and he finds him there at the place where he's fired and his firearm, and he tells him, go home so that we can investigate this. This is not a disciplinary process that is started. This is clearly to allow the investigation on the scene of the shooting. This is a lawful instruction given to that police officer to go home to allow the investigation on the scene of this incident.
Section 207, subsection 2 of the Constitution prescribes that the National Commissioner must exercise control over and manage the police service in accordance with the national policing policy and the directions of the cabinet member responsible for policing. This is the constitutional provision that Masemola sought to invoke in defense of his decision, arguing that the administrative action was in line with the law in an effort to trump Sibiya's argument that there was no source of power that gave him the authority to place him on leave of absence.
If one takes into consideration his duties and obligations in terms of the Constitution, and one read that together with Section 11 of the Police Act, and I refer to that in paragraph 17 of my heads, and specifically I'm referring, Your Lady and Your Lordships, to subsection 2G, where it says, the National Commissioner may exercise his power and shall perform duties and functions necessary to give effect to the section, and then goes to G, perform any legal act or act in any legal capacity on behalf of the service.
But Sibiya wants the High Court to interdict Masemola from making further disciplinary decisions against him and, in the alternative, seeks a suspension of any disciplinary decisions that have already been taken.
It is our contention that his application that he brought, this application, is completely premature. And in fact, it is done with the exclusive intention of stopping any investigation against him.
Sibiya argues that he will be subjected to two processes that may even have different outcomes: the internal investigation by the SAPS and the Nhlanhla inquiry established by President Cyril Ramaphosa to probe the allegations of rot within the police service. His superior, however, believes these processes can run concurrently.
The police service cannot abdicate the responsibilities to maintain order and discipline within the police ranks to anybody else. And that will come later when I argue in relation to the second, the third and fourth prayer. What the applicant wants the police to do is to stand back and to say, well, we've got this duty to manage and control the police service, but this is a hot potato. The Commission must rather take this, and the Commission must rather adjudicate this. This can never be.
This relief is one that the full bench of the High Court appeared to grapple with.
If there is serious misconduct which will jeopardize the relationship between the employer and the employee, or between the commander and the second in command, and an independent disciplinary chairperson sitting in terms of the regulations finds that it is so serious that the relationship should terminate. And that's also the sanction in the disciplinary inquiry. You say, but that shouldn't take place. That possible prejudicial relationship should remain in place for 3 or 6 months or a year until the Commission is finalized, after which the Commission may make the same recommendation to the Minister, but then only will disciplinary steps then have to take place. And in the meantime, the status quo should remain.
Masemola submits that there's no limitations in the terms of reference of the Nhlanhla inquiry that exclude his constitutional mandate and authority. He also charges that there are no grounds that, pending the outcome of investigations by the Commission, that all functioning of the police service and internal processes to ensure discipline must be suspended, and analysts agree.
The issue is that Mr. Sibiya really didn't give effect to an instruction by his superior that the phasing out of the political killings task team should be phased out as opposed to being immediate, then the issue is, why would that require the Nhlanhla Commission to be dealt with? Because that's a direct contravention of, a superior's instructions. So I don't think that argument will hold water because of what we're dealing with in this particular instance. It's a contravention of an instruction from a superior. Yes, it may collaterally spill into the other areas, but that's it's a discipline issue within the police and not a Nhlanhla Commission issue.
All the while, the 121 dockets had been languishing at the head office in Pretoria until last week when Masemola returned them to KwaZulu-Natal. But this quickly changed after a joint statement by the head of the SAPS and his new political head, Acting Police Minister Zoleka Qodashe, stating that they would be redirected to the Commission, and it appears the bench is also cognizant of these events.
What is your client's evidence? What does he say should happen with 121 murder dockets while the Commission continues for an indefinite period?
I'm not sure that he has to say anything about that. Does he?
Well, that's not the question. My question was, what does he say? If your answer is he doesn't say anything, that's an answer.
No,
but you can't pose a counter question.
I'm trying to understand the scope of the question. Is the question, what does he say happened with the 120?
No, what does he say should happen? What does he say should happen? You say he needn't say anything.
Sibiya, meanwhile, alleged that he attempted to send the dockets back to KZN. However, Mkhwanazi allegedly rejected them. The squabbles within the police top brass, along with the tug-of-war over the criminal dockets, has severely diminished the already waning trust in the police service.
Well, one of the main reasons we've seen this massive fracture at the top leadership was as a result of the so-called disbanding of this unit back on the 31st of December 2024. And this is the rationale behind, or part of the rationale behind, the press conference early July by Mkhwanazi and the subsequent developments we've seen with the suspension of General Sibiya by General Masemola. So I think everybody's kind of concerned, where are these dockets? Are they going to be reinvestigated? This rift that's occurred in the top leadership of SAPS, is it being remedied? What's going to happen? And of course, everybody was relieved by the president returning from Brazil and talking about the fact that this commission is going to be established. But now we're seeing that this commission, although established on paper, has yet to hear its first witness. So again, this trust deficit between the police and the population of this country is becoming almost non-existent.
South Africa has seen this movie before, where in the political realm, those running the country's security apparatus have fought tooth and nail and in court to clear their names and quash allegations by their detractors. This battle, which ostensibly has implications for who becomes the country's top cop, is likely to drag on for months, if not years. You'll want to stay tuned to Newzroom Afrika on channel 405 as we keep a close eye on these developments and unpack them as they unfold. I'm Zoleka Qodashe, and thanks for watching.